My respectful greetings to Professor Subir Bhatnagar, Vice Chancellor of Dr. Ram Manohar Lohiya National Law University, Dr. Ved Kumari, Vice Chancellor of the National Law University Odisha, Mr. Nidhesh Gupta and Mr. Siddharth Bhatnagar, learned senior advocates, learned members of the foundation, audience in attendance, and my dear students. I consider it a great honor to participate as one of the speakers in the second Justice HR Khanna Memorial National Symposium organized to commemorate the colossal persona of late Justice HR Khanna. In the first session of the day, I had the pleasure and privilege to hear my esteemed brother, His Lordship Justice Vikram Nath, who spoke on the fundamental duties vis-a-vis fundamental rights under our Constitution. I have been requested to speak on the topics Vox Populi versus Rule of Law, Supreme Court of India. To pay tribute to late Justice HR Khanna, the former judge of the Supreme Court of India, by itself is a great honor bestowed upon me. Jean Monnet, father of the European Union, once said, I quote, "The world is divided into two types of people, those who want to be somebody and those who want to do something," I unquote. Justice HR Khanna is remembered and will always be remembered long after many Chief Justices of India are forgotten, because he did something for which he deserved to be remembered. Justice HR Khanna has been one of the greatest judges of the Supreme Court of India. His towering contribution to the judicial system of the country is immeasurable. A couple of months back, while I was a judge in the High Court of Gujarat, I, being an administrative judge of the Rajkot district, had to visit Rajkot. While I was in Rajkot, I was requested by the Rajkot District Bar Association to spare some time and address the members of the bar. I kept wondering on what subject I should address the members of the Rajkot District Bar Association. Ultimately, I decided to speak on the rule of law, least knowing that I would be talking on the rule of law as a Supreme Court judge in next few months. While addressing the members of the legal fraternity at Rajkot, I said that there are two basic roles of a judge. First, to uphold the Constitution and the rule of law. And secondly, to bridge the gap between the law and the society. In my address, I remember Justice Khanna, as I could not have explained what is rule of law in a better manner without quoting Justice Khanna. I made the members of the legal fraternity recall to their memory what Justice Khanna observed in the ADM Jabalpur's judgment. In the ADM Jabalpur's case, in his dissenting opinion, Justice Khanna observed, I quote, "What is at stake is the rule of law. The question is whether the law speaking through the authority of the court shall be absolutely silenced and rendered mute," I unquote. On Justice Khanna's resignation from the Supreme Court of India, the New York Times wrote an editorial titled, I quote, "Feeding Hope in India," I unquote, saying, I quote, if India ever finds its way back to the freedom and democracy that were proud hallmarks of its first 18 years as an independent nation, someone will surely erect a monument of Justice HR Khanna of the Supreme Court. It was Justice Khanna who spoke out fearlessly and eloquently for freedom this week in dissenting from the court's decision upholding the right of Prime Minister Indira Gandhi's government to imprison political opponents at will and without court hearings. The submission of an independent judiciary to absolutist government is virtually the last step in the destruction of a democratic society, and the Indian Supreme Court's decision appears close to utter surrender. I unquote. Eminent jurist Mr. Nani Palkhiwala wrote an article in honor of Justice Khanna after his resignation in the Indian Express and stated that there were still judges in our midst who were true to the light within them and who remained unmoved, unshaken, unseduced, and unterrified. He quoted the following lines in that connection. I quote, God, give us men a time like this demands, strong minds, great hearts, true faith, and ready hands, men whom the lust of office does not kill, men who possess opinions and a will, men who have honor, men who will not lie, men who can stand before a demagogue and damn his treacherous flatteries without winking, tall man, sun-crowned, who live above the fog in public duty and in private thinking. I unquote. Justice Khanna belonged to that creed of men who, having donned the judicial mantle, maintained the highest standards in their judicial career. Ladies and gentlemen, I came to be elevated as the judge of the Supreme Court on 9th of May 2022. Supreme Court closed for the summer vacation from 20th of May 2022. However, for the entire last week, I had the honor to sit with a senior judge of the Supreme Court during the vacation. For the first time, I had the honor to sit in the court number 2 of the Supreme Court. I noticed that as a mark of respect, Justice Khanna's portrait has been displayed in the court number 2, where he used to sit and decide the cases. His portrait inspires the lawyers and the judges to follow his cherished values and principles. A Chief Justice of the New York State of Appeals, on his first appointment as a Chief Judge, proudly showed his wife the chair in the courtroom of his illustrious predecessor, or in office of nearly half a century ago, Chief Justice Benjamin Cardozo, a legend among judges of the United States. And he said to his wife in a reverential whisper, "See, this is Cardozo's chair, and this is where I will sit." His wife responded, not very reverentially, "Yes, and after 50 years and 5 more Chief Justices, it will still be Cardozo's chair." Ladies and gentlemen, the times would run through, and yet Justice HR Khanna would be remembered as Justice HR Khanna, with none who can surpass him. Let me now talk about on today's subject, Vox Populi versus rule of law. First, about the origin of the phrase, Vox Populi. Voice of the people is the voice of God is mistakenly assumed as to how it originated. It is interesting to note that actually it was stated in a disapproving manner. The full quote is in a letter to Charlemagne or Charles the Great from Alcuin of York, an English scholar and clergyman in 798 AD. What Alcuin wrote, I quote, "And those who believe should not be listened to who keep saying, the voice of God, Vox Populi, Vox Dei, since the noisiness of the crowd is always very close to madness. The voice of the people is the voice of the God," was first used by the English Archbishop of Canterbury, Walter Reynolds, during a sermon in 1327 against King Edward II, who the Archbishop wanted removed from the throne. Reynolds was backing the wife, Queen Isabella, in her rebellion against King Edward II. Balancing the intent of the majority populace on one hand and meeting the demands of affirming the rule of law on the other is an arduous exercise. It requires extreme judicial craftsmanship to walk the tightrope between the two. What would people say? Log kya kahenge? Kya sochenge? Is an enigma which haunts each and every judge, every moment whenever he is to pen down a judgment having social ramifications. It is where the conviction, awareness of the constitutional values and conceptual understanding of rule of law of the concerned judge comes to the fore. When we use the term view of the public, it is not always synonymous with people in general or the head count of masses. I must say that the term is quite often misunderstood and misinterpreted. View of the people in the constitutional context implies a segment of society, a section of people that has some common shared interest sitting at the same table. It is often said that the rule of law is the most distinguishing feature of Indian democracy, which has begun its career under the Indian Constitution from the 26th of January 1950. Considered verbally and literally, this claim may sound to be unreasonable because even in countries which are not governed by a parliamentary form of democracy, rule of law in substance prevails. Even dictators have their laws and they are enforced, and in that sense, even the dictatorship can claim that it rules by law, and so the rule of law prevails in its country. That is why the claim that the rule of law is the most distinguishing feature of Indian democracy must be closely scrutinized at the outset. When we make the claim that the rule of law distinguishes Indian democracy, we have two significant factors in mind. The first factor is in relation to the mechanism of the making of Indian laws. The making of Indian laws is characterized by 3 Ds. Before a law is introduced in the legislative chamber, its merits are freely, fully, and fearlessly discussed in the press and on the public platform. When it is introduced in the legislative chamber, it is debated by the legislators who have been elected democratically on adult suffrage and members of the opposition ruthlessly criticize it. And when it is passed, its validity is tested in the courts of law. Thus, public discussion, debate in the legislature, and the decree of the court are the three Ds which distinguish the mechanism of Indian lawmaking. And in this behalf, the Indian law differs from the law that is made by governments other than the parliamentary governments controlled by written constitution. When I refer to the decree of the court, it is necessary to explain how the courts come to have a decisive role, decisive voice in the determination of the question as to whether the laws are valid or not. A plea that a law passed by the British Parliament is invalid is inconceivable under the constitutional law in England because the sovereignty of Parliament is literally absolute. The Indian legislatures, federal as well as state, are no doubt sovereign in their respective spheres, but their spheres have been specifically defined, and if they traverse beyond their prescribed spheres, the acts that they pass are liable to be challenged in the courts of law. The legislative incompetence is thus one basis on which the validity of laws can be challenged in India. The other basis on which the validity of laws can be challenged is in relation to the fundamental rights of the citizens guaranteed by the Indian Constitution. The Constitution has been framed on the basis that the individual citizens are entitled to certain fundamental rights, which are enshrined in its most important provisions. The Constitution has also provided that these fundamental rights can be regulated effectively by legislation, provided two tests are satisfied. The invasion or regulation of the fundamental rights must be reasonable, and it must be in the interest of the public good. Thus, a challenge to the validity of any legislative enactment can be made on the ground that the impugned legislation unreasonably impinges a citizen's fundamental right, or is otherwise not in the interest of public good, and these issues are justiciable in the courts of law. It is on the basis of these two grounds that the courts in India have been empowered to pronounce their verdict on the validity of legislative enactments. That is a very distinguishing feature of the laws that are made in India. It is from this point of view that we claim in India that the rule of law is the most distinguishing feature of Indian democracy. I firmly believe that there is no exception to it, that the rule of law must prevail, and public opinion hardly has to be subordinate. It has to be subordinate to the rule of law. In the words of Rose Bird, the former Chief Justice of the California Supreme Court, I quote, "The judiciary must not take on the coloration of whatever may be popular at the moment. We are the guardians of rights, and we have to tell people things they often do not like to hear," I unquote. I firmly believe that it is for the highest court of this country to decide any issue, keeping only one thing in mind, and that is the rule of law. The judicial verdicts cannot be the reflection of the influence of public opinion. However, I must not forget to make a mention of what the learned members of the Constituent Assembly discussed while deliberating on the content of the different articles of the Constitution. In the Constituent Assembly debate, dated 10th of December 1948, Professor K.T. Shah opined that the inclusion of Vox Populi in our Constitution was a necessity, as it signified that at the end of the day, the will of the people was supreme. He noted that there are those who were against people's sovereignty, in fact and in name, claiming that the people are not ready or that they are not educated enough to give any decisive opinion on such complicated issues of foreign or local policy, while graciously accepting the fact that the literacy among the people was less. They were all sincere and true, and in their belief that ultimately the people are sovereign. He said, I quote, "Where there is collective wisdom, there is after all real salvation. Vox Populi, the voice of the people is the voice of God." End quote. It is very clear that he was of the view that the sentiments of the people must be given respect when it comes to judicial decision making. However, there is also a school of thought that goes against this belief. I belong to this school of thought. It emphasizes the need to disassociate oneself from the belief of the majority and go by the rule of law. The great thinker, John Stuart Mill, made a strong argument against popular morality being codified into laws. He stated that a popular distaste for an act or a thing cannot be classified as harmful or illegal only on the premise that it contradicts their beliefs or views. Hart expounded his warning about the imposition of majoritarian morals through the judicial opinions. He underscored, I quote, "No one should think, even when popular morality is supported by an overwhelming majority or marked by widespread intolerance, indignation, and disgust, that loyalty to democratic principles requires him to admit that its imposition on a minority is justified." End quote. I believe that in a democracy, we have a systematic agreement to live by the court decisions. It does not mean that the court decisions are always right or free of all other considerations. We simply agree to live by them. In a democracy, knowledge is more important than the systematic and blind obedience to the popular verdicts, whether of the electorates or courts. It is true that while a judge's role is to uphold the law, the judge in an exceptional case may have to be cognizant of the sentiments of the society and the perennial effects of the judgment that he may utter. One of the earliest decisions during the nascent stages of our republic was the abolition of the jury system. The jury system's biggest criticism has always been that it flows with the majority will of the people and it adversely hurts the minority. while the trained judicial mind follows the letter of the law. The 14th Law Commission, apart from the other factors, also relied on the views of the father of the nation, Mahatma Gandhi. Gandhiji said that he was unconvinced of the advantages of the jury trials over those by judges. Thus, the trust on the judiciary over juries led to the abolition of the jury system. The finest example which can be cited in the modern times, wherein the Supreme Court upheld the rule of law versus majoritarian perceptions, is the Navtej Singh Johar's case, where Section 377 of the Indian Penal Code was struck down to the extent it criminalizes consensual homosexual acts between adults. Honorable Justice Nariman, in his opinion, held, I quote, "The very purpose of the Fundamental Rights chapter in the Constitution of India is to withdraw the subject of liberty and dignity of the individual and place such subject beyond the reach of majoritarian governments, so that constitutional morality can be applied by this court to give effect to the rights, among others, of discrete and insular minorities." The Fundamental Rights chapter is like the North Star in the universe of constitutionalism. Constitutional morality always trumps any imposition of a particular view of social morality by shifting and different majoritarian regimes, I unquote. Honorable Justice Dr. D.Y. Chandrachud held, I quote, "In the quest to assert their liberties, people criminalized by the operation of the provision challenge not only its existence, but also a gamut of beliefs that are strongly rooted in majoritarian standards of what is normal. In this quest, the attack on the validity of Section 377 is a challenge to a long history of societal discrimination and persecution of people based on their identities. They have been subjugated to a culture of silence and into leading their lives in closeted invisibility. There must come a time when the constitutional guarantee of equality and inclusion will end the decades of discrimination practiced based on a majoritarian impulse of ascribed gender roles. That time is now. Under our constitutional scheme, no minority group must suffer deprivation of a constitutional right because they do not adhere to the majoritarian way of life. By the application of Section 377 of the Indian Penal Code, MSM and transgender persons are excluded from access to health care due to societal stigma attached to their sexual identity. I unquote. No one could have put it in a better manner than Justice Dr. D.Y. Chandrachud. When we look at the landmark verdicts of the Supreme Court, like the ones in the cases of Sabarimala, LGBT rights, or those on death penalty, the friction between the aspirations of the society and the necessity of upholding the rule of law comes to the forefront. Let us recall to our memory the observations of the Supreme Court in Sabarimala's case. It's very important. I quote, "Let every person remember that the holy book is the Constitution of India, And it is with this book in hand that the citizens of India march together as a nation so that they may move forward in all spheres of human endeavor to achieve the great goals set out by this Magna Carta or Great Charter of India. Constitution is the will of the people, whereas the statutory laws are the creation of the legislators who are the elected representatives of the people, where the will of the legislature declared in the statutes stand in opposition to that of the people declared in the Constitution, the will of the people must prevail. The Constitution of India provides for an elected president. House of the people is elected. The state legislators are elected. The Supreme Court judges are not elected. They are appointed under the Constitution. So are the High Court judges. Yet the Constitution confers power called judicial review, under which the court may nullify the unconstitutional acts of the executive and of the elected representatives of the people assembled in the parliament and the state legislatures. This conclusion does not necessarily suppose that the judiciary is superior to the legislature. It only supposes that the power of the people embodied in the Constitution is superior to both. The role of the judiciary under the Constitution is a pious trust reposed by the people. Let me also talk about the role of media. A trial is essentially a process to be carried out by the courts. However, in the modern day context, trials by digital media are an undue interference in the process of justice dispensation, crossing that Lakshman Rekha many a times. This is especially all the more worrisome when those sections of people start scrutinizing the judicial process who possess only the half-truth, those for whom the concepts of judicial discipline, binding precedents, and inherent limitations of judicial discretion are elusive. This section of people, the half-truth knowledgeables, are a real challenge to the dispensation of justice through the rule of law. Social and digital media is nowadays primarily resorted to expressing personalized opinions more against the judges per se, rather than a constructive critical appraisal of their judgments. This is what is harming the judicial institution and lowering its dignity. The constitutional courts have always graciously accepted informed dissents and constructive criticisms, but their thresholds have always debarred the personalized agenda-driven attacks on the judges. This is where the digital and social media needs to be mandatorily regulated in the country to preserve the rule of law under our Constitution. Attacks attempted at judges for their judgments lead to a dangerous scenario wherein judges would have to pay greater attention to what the media thinks rather than what the law actually mandates. This puts the rule of law on the burner, ignoring the sanctity of respect for the courts. In the case of Sahara Private Limited versus SEBI, the Supreme Court devised the doctrine of postponement of publication. It is a precautionary measure where the media is not allowed to publish opinions about the sub judice matter till the hearings conclude. This doctrine of postponement is not to be read as a censorship or a prior restraint, but rather a safeguard against possible abuse. This can be one of the viable options, considering how the non-judicial factors are shaping the public opinion in this matter. A judicial verdict, right or wrong, is always by a court vested with powers under the Constitution of India as a court of record. The Supreme Court and the High Courts act as court of records by virtue of Articles 129 and 215 respectively of the Indian Constitution. The remedy of any judicial order or a judgment is clearly not available on digital or social media, but before the superior court of law in the judicial hierarchy. In India, which still cannot be classified as a completely mature and informed democracy, social digital media is employed frequently to politicize purely legal and constitutional issues. One of the cases in hand is the Ayodhya verdict, which was essentially a land and a title dispute bordering upon the title of a deity. However, by the time the final verdict came to be delivered, the issue attained political overtones. All those imputing intentions and motives to the Supreme Court for the Ayodhya verdict conveniently forgot that someday or the other, some judge had to decide the contentious civil dispute, which was indisputably one of the oldest litigations pending in the court of the country, running into more than 38,000 and odd pages. This is where the heart of any judicial proceedings before the constitutional court may disappear, and the judges deciding the dispute may get a bit shaken, which is antithetic to the rule of law. This is not healthy for the rule of law. Another issue which has always been a hot cake for the social and digital media is the punishments in cases of serious offenses. The immense power of these platforms is persistently resorted to for precipitating a perception of guilt or innocence of the accused even before the trial is over. This also sacrileges the rule, especially in high-profile matters where either the incident is hyped or the accused is a big man. Even before the trial is over, the society starts believing that the outcome of judicial proceedings ought to be nothing except conviction with the extreme penalty for the accused. Therefore, regulation of digital and social media, especially in the context of sensitive trials, which are sub judice, must be dwelled upon by the Parliament by introducing appropriate legislative and regulatory provisions in this regard. The question arises of how to resolve these concerns. A number of legislations, namely amendments to the Information Technology Act 2000, the Contempt of Courts Act 1971, are in place to tackle the problems of interference with the judicial processes, especially in sensitive sub judice matters. There have been several studies, reports, and recommendations, both nationally and internationally, suggesting ways and measures for handling the perpetual problem of media trial, especially through the digital and social media. One of the notable being the Madrid Principles of 1994, focusing on the interrelationship between digital social media and judicial independence. Madrid Principles essentially are an extension of the United Nations Principles on the Independence of the Judiciary from 1985, formulating rules and codifying guidelines delineating the boundaries of freedom of speech in the context of judicial independence. The preamble to the Madrid Conference, laying emphasis on the rule of law, reads thus, I quote, freedom of the media, which is an integral part of freedom of expression, is essential in a democratic society governed by the rule of law. It is the responsibility of judges to recognize and give effect to freedom of the media by applying a basic presumption in their favor and by permitting only such restrictions on freedom of the media as are authorized by the International Covenant on the Civil and Political Rights. I unquote. The Madrid Principles have emphasized that it is the function and right of the digital media to collect and share the information with the public on the administration of justice, however, with appropriate checks and balances. Also important are the International Bar Association Legal Policy and Research Unit recommendations. The International Bar Association Legal Policy and Research Unit in 2011 carried out a global survey to consider the impact of online social networking platforms on the judicial system. 61 bar associations, including the Bar Council of India, from 47 jurisdictions across the globe responded. The report indicated that while the social media was a platform for discussion, wherein decisions of the courts may be criticized, judges should not succumb to its pressures. They must be loath to be influenced by it. Furthermore, this report minced no words in emphasizing that judges should not themselves resort to social media platforms by becoming privy to any such debates. This would do more harm than good for the rule of law, as judges never speak through their tongue, but only through their judgments. Ladies and gentlemen, at the end of the day, I may only say that judiciary cannot exist independent of the society, and the interaction is inevitable. But the rule of law is insurmountable. I am once again thankful to the distinguished guests for this honor. I also extend my thanks to the Ken Foundation. The students behind the foundation also deserve a huge applause for their determination and commitment to assist the foundation in its organizing of webinars like the current one, and also in other projects that the foundation is involved in. Thank you very much, Mr. Nidhesh Gupta. Thank you very much, Mr. Siddharth Bhatnagar. It was a pleasure having you all on this symposium. Thank you very much, Professor Bhatnagar and Dr. Hope to see you all one day again on some debate. Thank you very much. Thank you so much.